shareholders dispute is basically what it says. It's a dispute that arises between the owners of a business, sometimes the owner managers of the business, as to how the business is going to progress. And I see anything from a dispute between equal owners of the business as to how that business is going to go forwards, to things a little bit more serious, such as a minority shareholder being excluded from the business, to a majority shareholder who wants to exclude a minority shareholder from the business because of his or her conduct, perhaps. It's a very stressful time for a shareholder who is involved in a dispute, and we try to take all that stress and pressure off the client by giving them very clear options as to what they can do going forwards. We help them with the negotiation, and quite often you find that parties who've fallen out, they can't deal with that negotiation themselves. They're very good business people and are able to deal with negotiations, but where you've got that emotion involved, they can't necessarily do it. We'll then advise the client on how to get the best from the negotiations by using things like without prejudice discussions, but also mediation, to avoid our clients getting involved in lengthy court battles and avoid the court process completely in most occasions. It's difficult to prevent a shareholders' dispute from arising at all, but to put yourself in the best possible position, you really should have a professionally drafted shareholders' agreement, and that should really be done right at the start of when the business is formed. So at the same time that the articles of association are being prepared and you're thinking about what you want to do going forward. And I appreciate it's a bit like having the divorce before the marriage, but it really can save a lot of stress and hassle. From experience that I've dealt with, we often as soon as we meet the clients who are in a dispute between shareholders, we think to ourselves, this would have been a good few months less legal work had there been an agreement in place. And that's because valuing a business is pretty much an art rather than a science. It's well worth getting that shareholders agreement drafted at the start to prevent those headaches and hassles further down the line. So the shareholders agreements are between the owners and management of the business, and it is private, so it isn't registered at Companies House, so it can pretty much include anything that the shareholders need it to. So we will sit down and have a consultation and look at what it is that they need to achieve, as well as putting basic things in there, such as if the business is to be sold, that all the shareholders have got to participate in the sale, as well as the mechanism to value shares if one shareholder needs to leave. The aims here at Stephensons is that we'll work with our clients to come up with an end goal and result, which usually is a valuation of the shareholding involved, and we'll work with expert accountants to get that valuation done. So if you've got an existing business and you haven't got a shareholders agreement, then give us a call to discuss your needs, and if you are thinking about setting up a business, then the shareholders agreement should be something that you think about doing at that time. So just pick the phone up, ask to speak to commercial, and we can help you from there.